Dear colleagues, I'm glad to welcome you at our webinar. The topic today is Corona crisis. Health comes first, but not to forget about business. Many people throughout the globe these days are so united as never before. But unfortunately, the point of unity is not that good, but we have what we have. First, I will talk about some aspects that I consider to be important. You can send your questions to the chat, and I will answer them upon the end of my presentation. And I will ask you to prepare your questions in English so that anyone who participates in this webinar could understand them. First, I will talk about current labor and migration law restrictions and requirements in view of Corona crisis in Russia. There are three main levels of regulation. Federal level, which includes, for example, a resolution of the government on temporary prohibition or restriction of entry of foreign citizens into Russia. This government resolution now is in force until the 1st of May, but nobody knows whether it will be prolonged or not. The second level is regional. Each region in Russia adopted its own set of measures and restrictions. And finally, local regulation that each company or group of companies establishes now for itself. Let us look at the latest act at the federal level, because I'm sure that for most of you this is now the most striking topic. This is the decree of the President of Russia announcing next week as a non-working one. I will now focus on this document. The exact requirement in this decree is indicated as follows. Days from March 30 till the 3rd of April are established as non-working days subject to retaining salary of employees. I will try to comment on this as I understand it. The Labor Code uses the exactly same term non-working day only once in Article 14. If the last day of a term, for example, end of probation period, notification period in case of staff redundancy, and so on, ends on a non-working day, then the term end is shifted till the next working day. It is important to note that the decree of the President does not define these 5 days as weekend days or holidays. Therefore, I can construe it literally that employers during these 5 days cannot or may not engage employees for work unless certain exceptions apply. It is also not foreseen that employers may engage employees in the manner as on weekend days, which means with double pay. However, in view of the sense of this measure, if employees work from home without written or other explicit instruction of the employer, it shall not be regarded, from my perspective, as a violation and does not require any additional payment except for salary retained. It is important to note that unlike in the speech of the President that he proclaimed yesterday, the decree does not call 28th and 29th of March, as well as 4th and 5th of April, as non-working days. Thus, employers may still engage employees, subject to their consent, during these weekend days in a usual manner, unless for sure such exceptions as quarantine, preventing work outside the office, or old age apply. There are some exceptions when the decree does not apply that are explicitly listed in the decree. So if some of the exceptions apply, employees of relevant organization may work next week as usual. One of these exceptions is when the company exercises repair works that cannot be delayed. We consider that it may apply to work of, for example, many service engineers, though for sure it should be checked on the case-by-case basis. Other notable exceptions include employees of so-called constantly operating enterprises, which means when shifts go one by one. Also, it concerns employees of food retail chains for sure, as well as organizations that fulfill works in emergency circumstances if such works cannot be delayed. As an example of such work is, for example, fulfilling urgent order for hospital or the stuff like that. Exceptions also concerned mass media to a limited extent, but mass media shall determine on their own a number of employees who will make them operational next week. But there are no any criteria what part of employees may stay at work and what part shall stay at home and do not perform any work. So basically it could be up to basically all employees. It is important to note that based on literal interpretation of this decree, these exceptions apply not only to separate employees, but to organizations that exercise relevant types of activities. That means that basically if support staff is needed for the purpose of supporting relevant production activities during next week, which fall into the list of exceptions, such support staff may also work. But for sure, bearing in mind the sense of this measure, and the sense is that people mostly stay at home, which may minimize spread of the virus. So bearing in mind the sense of this measure, it is for sure advisable that people who are not directly involved into production processes that fall into the list of exceptions, that they stay at home. If we talk about employees who will still come to the production sites or to the offices, it is recommended that the company has a good and precise documented justification of these employees during working during next week. This is needed for the case inspections are conducted afterwards or during the week. This justification could include contracts with relevant timelines, urgent orders, job descriptions, showing that employees do namely that work that is required to fulfill such orders. Other internal instructions in relation to such orders, and so on. In general, if we talk about formalizing work of employees next week, it is recommended to issue an order, an internal resolution, which is signed by the general director of the company. And in this order, you may indicate, you may refer to the decree of the president and relevant points of this decree that justify work of separate employees during next week. From my perspective, it is enough to acknowledge with this order only those employees who in fact will or are intended to work next week. Regarding payment of salary during next week, it is stated in the decree that salary is retained. Thus, I construe it as it should not change during non-working days. It shall stay the same. And again, I would like to stress that the period from 30 March until 3rd of April is declared as non-working days and not weekend days. Therefore, no compensation for work during weekend days is due. And if, for example, the company engages employees to work without relevant justification for that, it may be regarded as a violation of labor legislation and lead to relevant fines, but it shall not give a ground for employees claiming additional compensation in addition to the normal salary that is retained. And if we talk about applying exceptions that I listed before, then basically the work is done as usual. Employees just receive their normal salary for this period, because in this case the decree, according to point 2 of the decree, does not apply. Obviously, if you engage employees, even if you refer to relevant exceptions, it is still required and necessary to think about such things as transportation of employees to the site, to minimize use of public transport, such as distribution of relevant protective means to employees, and so on. There were questions as to whether it's possible, maybe not next week, but a week after, if this measure is prolonged, which nobody can exclude now, whether it's possible just to introduce a kind of idle time regime, which means in Russian "prostoy." I would say that no, because these days are declared as non-working ones, and therefore introduction of idle time is not possible. And the guarantee to retain payment of salary is also set in a way that it does not depend on whether employees may perform their job duties during next week or not. What I can propose as maybe some kind of mitigation of financial impact is proposing to employees to shift their vacation days, as vacation days are provided in calendar days, and it is not prohibited by this decree or by the legislation to take vacation days during non-working days. Because if the employee uses one part of his or her vacation per year, which is 14 consecutive calendar days, then it is not prohibited to distribute further vacation days also on non-working days. It is also notable and very, I would say, actual now, that if according to internal regulations in your organization, you have to pay salary to employees for the second half of March on the last day of a month or in first 5 days of next month, salary for March shall be paid not later than tomorrow, on Friday, because the general rule that salary shall be paid on the last working day before non-working days applies in this case also. We have the information that in some ministry, and this is so far not the Ministry of Labor, there is another interpretation of this decree. People say that even if employees fall into exceptions set by the decree and they are engaged to work next week, they shall get double pay. I consider that this interpretation is not correct, but I would recommend waiting for some clarifications of the Russian Ministry of Labor. That it was announced that the Ministry of Labor will come up with such clarifications, hopefully today, maybe latest tomorrow morning. And based on these clarifications, we will all be able to understand maybe a little bit more of how to go on with business in these unusual circumstances. Let us talk now about specific obligations of employers in Moscow as an example. First of all, employers shall ensure temperature measurement by employees in the office. I would say that nobody would ever check compliance with this requirement unless, unfortunately, an employee of the company gets ill, and then the whole staff is quarantined. Therefore, in order to be able to prove that the company complies with this requirement, it is necessary to indicate results of such temperature measurement in special logs, and every employer actually defines the form of such logs on its own. But obviously, as an example, if on one day body temperature of an employee is 38, then on the next day he or she shall not appear to work because he or she shall be suspended from work in this case. All employees who have working places shall be subject to such temperature measurement. Thus, basically, only remote employees are exempted as they do not have working places. And regularity of temperature measurement is not set, but as there is a corresponding obligation of the employer to suspend from working places those employees who have higher temperature, it is necessary and recommended to make this every day. In some places, high temperature is regarded as 37.3. In Russia, it is usually already just 37, but for sure some margin of error of medical thermometers may be allowed. But this margin shall be confirmed in case of necessity by the instruction attached to the thermometer. An obligation of the employer is to ensure temperature measurement, and this means first buying necessary quantity of thermometers and control that employees use them. There is a question whether the company has to ensure temperature measurement also in relation to agency employees. I mean, if the company uses outsourced personnel in the place of its location. Legally, according to the decree of Moscow mayor, it is an obligation of the agency to ensure measurement of temperature of such employees. But again, in view of the sense of this measure, the inviting party and the agency, the outsourcing agency, may agree on assistance of the inviting company with such temperature measurement in relation to agency employees. If an employee has a higher temperature, then the employer is obliged to suspend him or her from being at a workplace. That means отстранить от нахождения на рабочем месте. This legal term suspension from being at a workplace is not the same as suspension from work. What is the procedure for suspending an employee from being at a workplace in this occasion? Ideally, an employer and an employee may agree on temporary remote work or home office if job functions of an employee allow that. Alternatively, an employee may call a doctor and take a sick leave or take vacation if agreed with the employer. But if no agreement is possible or work cannot be done at home and the employee doesn't want to take sick leave or vacation, I consider that suspension from work may take place according to Article 76 of the Russian Labor Code. One of the grounds for suspension from work, according to Article 76, is demand of officials authorized by federal laws. Here we can look at the Article 4.1 of the Federal Law number 68 on protection of population from emergencies. This article empowers regional authorities to take protective measures against spread of emergency. And, for example, Mayor of Moscow issued such a decree that sets a number of demands, including demand to suspend employees from being at a workplace in case of higher temperature. Suspension is formalized through an order of the General Director, and an employee shall be acquainted with this order against signed receipt. It is notable that the employer is entitled not to pay salary during the period of suspension if no work is done during this period. Another point is employees who come from abroad and shall stay on a 14 days quarantine. So in case such employees come from abroad, they may take sick leave or work remotely. Because it is also an obligation of the employer not to let, so even not to suspend, but not to let employees come in from, for example, all European countries, United States, China, and other countries to the office. In this context, the employer may ask for information on all personal trips of employees abroad. So this will not be a violation of privacy rights of an employee under the current circumstances. The best way for sure to to control compliance with this obligation of employees would be to ask them to store travel and passports in the office, but this could be regarded as a violation of employees' rights. Therefore, in my view, legally, it is enough to oblige employees to provide such information through an internal resolution and bring this resolution to their attention against such receipt. So in cases employees do not comply with this resolution, it may lead to not good consequences for them. Everybody, I think, knows about the precedent in Stavropol region, where a doctor secretly returned from abroad and did not tell anybody about that, and went on going to work. Now there is a criminal investigation around that. Most of you have seen a government resolution on ban of entry of foreign citizens into Russia and suspension of issue of work permits to them. I would say that this resolution is formulated very strictly, but the Ministry of Internal Affairs a little bit, I would say, softened impact of this government resolution through an internal order. First of all, if foreign citizens, for example, highly qualified specialists, stay in Russia, they may both apply and receive work permits and prolonged visas. I can say that in Moscow, in Sakharova village, it is and it was possible starting from the beginning of this week. However, I would say that in practice there is an issue with employees from so-called migration risk countries, so such as CIS countries, Turkey, and many others. In practice, employers may file documents for work permits for highly qualified specialists for citizens of such countries only upon a meeting of the management of the company with the management of the migration authority in this region. And for example, in Sakharova, such meetings are suspended. There is an information that this suspension will last until the end of April. Despite the fact that for private companies, for most private companies, employees of such companies next week will be a non-working one, state authorities go on exercising their duties, and there is an information that next week, most likely, migration authorities will go on working and perform such functions as issue of work permits, prolongation of visas, and so on. One more aspect here. According to the recent changes to the law, owners, foreign citizens who own permanent or temporary resident permits shall stay in Russia during a calendar year not less than 6 months in total. If we talk about highly qualified specialists, if they do not have a residence permit, they shall come into Russia at least each 6 months. Due to restrictions and quarantine, these requirements may be violated, and this may lead to annulment of these documents. However, again, there is an internal instruction from the Ministry of Internal Affairs not to annul these documents if violation is caused by coronavirus and related measures. Anyway, it is recommended to gain and keep relevant confirming documents for foreign citizens who, for example, now cannot enter Russia for objective reasons. To keep such documents as certificates from the foreign medical institutions, excerpts from legal acts restricting traveling, and so on, to do it in advance, to be able to prove that reasons for absence were justified. The very fact of pandemia, unlike in some European countries, is not a legal ground for introduction of short-time regime under the Russian law. Under the Russian law, the employer may unilaterally introduce short-time regime subject to the following numerous conditions. First of all, the employer has to prove underlying changes in organizational and technological conditions of work. Then the employer has to prove a risk. That means that it is a kind of hypothetical condition, a risk of mass redundancies as an alternative scenario in case short-time working regime is not introduced. Also, consultation with the trade union is required if there is such a trade union in the company. Employees shall be notified 2 months in advance. The employer has to notify also the unemployment center within 3 business days upon taking a decision on introduction of short-time work. Maximum duration of such short-time working regime is 6 months. And upon expiration of these 6 months, it is necessary to repeat all the mentioned procedure. If employees refuse working in short-time regime, according to the decision of the employer, they are subject to dismissal on the ground of staff redundancy, which in its turn implies another long and complicated procedure. In view of the above complicated conditions, we consider that this option does not really suit to the current circumstances. Therefore, it is recommended to introduce short-time regime by mutual consent of the employer and employee, because this option has many advantages, despite the main advantage that it requires a consent of the employee. So, for example, no notification terms apply. Normally, a reduction in working hours leads to pro rata reduction in salary. However, for sure, parties may agree on reducing salary and not reducing working hours. Such additional agreement to the employment contract may have limited duration, and this may serve as a kind of additional guarantee for the employee. The employee will understand that upon expiration of this period, normal time regime will apply again. It is also not a problem to sign such addenda distantly by exchanging counterparts through courier services. And it's also important to say that if you reach an agreement with an employee, it is hardly disputable. From the purely practical standpoint, I would say that most employees, like 80%, will agree on such extra measures unless reduction in salary is not that significant. So 20 to 25% may be acceptable for employees, especially if the salary in your company is denominated in a foreign currency due to a drastic raise in exchange rates. It may a little bit soften the negative impact on income of employees. Upon dismissal of a number of employees, because many companies unfortunately have to do this now because of decreasing production and volumes of services they render. So upon dismissal of a number of employees, the company may need to redistribute volume of work among remaining employees, which will enhance their workload. At the same time, it is possible to avoid overtime payments for additional work if open-ended working hours are agreed between the employer and the employee. As you know, in order to introduce an open-ended working regime, it is necessary to agree on that with the employee, to put a relevant clause into the contract, and to mention the position of an employee in the internal policy as a position requiring non-limited working regime. As a compensation for open-ended working hours, employees are entitled to get at least 3 additional paid vacation days per year. Also, it is notable that even if no open-ended working regime is introduced, according to the existing court practice, as long as overtime work is assigned not based on written instructions of the manager or company, employees lose a right to claim extra compensation for that, even if they do this extra job. Unlike, for example, Germany, where the model of accumulating so-called negative hours applies, it is not possible to apply this model in Russia unless a so-called cumulative or summarized time recording is introduced. Cumulative time recording means in Russian суммированный учет рабочего времени. In this case, working time is calculated in average for the recording period. For example, the recording period is 3 months. During 1 month, employees work 120 hours. During next month, 160 hours. And during the 3rd month, 200 hours, which in total and in average equals to 160 hours of work per month, which is more or less a normal duration of work for this period. This system normally does not apply to office staff, but it may, for example, apply to service engineers in your company. The condition for introducing cumulative time recording is when the company exercises certain types of activities and cannot ensure the normal working time duration for employees doing relevant job duties within these types of activities for the established period of time. There is such a condition in the law, but basically it is namely the company, the employer, that determines, in view of specific of its business, whether it may ensure normal duration of work during a week or not, or during a month. In case of disputes, courts shall not, and in practice mostly do not, interfere into business processes of companies and business discretion of companies. To introduce cumulative time recording, it is necessary to make relevant changes to the local policy, which should be internal labor regulations, to make relevant changes to employment contracts of respective employees, because this type of time recording is a separate one, is a specific one. It does not apply to all employees. Therefore, an employer shall specifically stipulate it in employment contract. And finally, to define a recording period. Normally, recording period cannot exceed 1 year. However, if employees have so-called hazardous employment conditions, according to their employment contracts or results of special assessment of workplace, in this case the maximum recording period is generally cannot exceed 3 months. So now many people work from home, and the company may consider implementing such flexible work models for those employees who do not have to attend the office. In particular, the recommended solutions would be either remote work, which is in Russian дистанционный труд, or home office. Home office option applies if you need to have more flexibility for the case you need to call an employee to the office for certain days. Remote work option applies if an employee may stay at home for the whole stipulated period. The option that you use basically depends on whether you need flexibility in terms of being able to call employees back to the office or not. So if you need such a flexibility, if you need to invite employees to work some days in the office, the home office regime, which is the right column on the slide, suits for that purpose better. If you can allow people to work remotely for the whole period, for example, of quarantine or of restrictions that apply, the remote work option would apply. This is the middle column in the table. I would say that now there are some plans to introduce a mixed model when remote work will be possible on a partial basis, meaning that employees may work remotely, which means дистанционный труд, on some days and work in the office on others. So far, unfortunately, legally, this is not possible. So if we compare these two options, basically both options may be introduced for a specific time period and subsequently extended. It is necessary to conclude supplemental agreements to employment contracts with employees in both cases. But in addition, if we talk about home office, in addition to addendum to the employment contract, it is necessary to establish a policy that mostly will address labor safety aspects. Because if you talk about home office, it's maybe one of the major differences from the remote work is that in case of home office, the employer stays responsible for labor safety issues. And therefore, the employer shall take some measures to procure that the employee is informed on how he or she should deal with the computer at home, with electronic equipment, and so on, how to make it safely. Because in case of remote work, such policy is not really necessary, because maybe the only duty in the sphere of labor safety in case of remote work, in case of дистанционный труд, is an obligation of the employer to investigate work-related occasions, work-related accidents. Unless prohibited by some other reasons such as quarantine and so on, basically both options allow business traveling. Even a remote worker can be called by an employer to the office on the ground of, for example, business trip. And I would also note that remote work is explicitly recommended for elderly people above 65 in Moscow now, until the middle of April at least. Let us now talk a bit about different types of quarantines. There are some changes planned regarding compensation for the time of stay at quarantine, but I will talk now about the current status. If quarantine is introduced in the kindergarten, where children under 7 stay, then an employee may get a sick leave certificate for the whole period of such quarantine. In Moscow, the employer pays to the employee compensation for quarantine period, but then reimburses the whole amount from the budget. In some regions, though, payments come directly from the Social Security Fund. And it's not prohibited for sure to stipulate some additional payments in employment contracts for such situation, because in many companies employees get additional compensation for several days or weeks of sick leave, but it is not explicitly stated. It is usually not explicitly stated that this also covers quarantine situations. So if quarantine is introduced in the kindergarten, it's more or less a safe and clear situation for both the employer and the employee. But if quarantine, as it is now, is introduced in the school, then it doesn't serve as a legal ground for the employee to stay absent from work, unless the child is ill. In this case, it shall be settled individually by way of, for example, home office, paid or unpaid leave, and so on. Employees may apply for unpaid leaves for family reasons, and the situation when a parent stays on quarantine together with the child basically may fall into this situation. And duration of such unpaid leave is determined by agreement between the parties. As regards paid leaves, although paid leave schedules for the year 2020 are obligatory for both the employer and the employee, it is still possible that the parties agree on changing such schedules and, for example, providing leaves for a period of contemplated quarantine, downtime, or similar. Employees who come back from abroad and have to stay 14 days on a quarantine may get a sick leave certificate by way of themselves filing an application through the website of the Social Insurance Fund. The important point that to make this, to get compensation for 14 days of quarantine, employees should also attach documents confirming the trip, such as copy of the passport, air tickets, check from the hotel, and so on. And also some words about idle time, about простой. If the company may not provide work to employees but does not plan dismissing them, it may temporarily introduce a so-called idle time regime to a part or even to all employees. And depending on the circumstances, the following options apply. In case there are regulatory requirements, for example, total ban on travel to certain territories or ban of events, closure of enterprises that render services to the population such as cinema, restaurants, and so on. And the employee cannot fulfill his or her job duties due to this fact, an idle time regime may be introduced on the ground of circumstances that are beyond the will of both parties. In this case, the employee is entitled to get remuneration in the amount of not less than 2/3 of his or her base salary for the period of idle time. In case there are limitations that are dictated by best market practice, for example, limitation of business trips within Russia, but are not required legally, an idle time regime may be introduced on the ground of the employer's fault. So we all understand that this is not the fault of employer, but legally it belongs to this category. So in this case, the employee is entitled to remuneration in the amount of 2/3 of his average salary. So most of you for sure know that average salary is calculated for last 12 months, and for example, bonuses paid are taken into account, which may raise the level of remuneration paid during idle time. It is notable that if you introduce idle time before dismissal of the employee, for example, there is a 2 months notification period and the company introduces idle time for an employee to be dismissed based on staff redundancy for these 2 months, that these may be ruled out as illegal. The reason is definition of idle time in the law. It is defined as temporary suspension of work. The key word here is temporary, which means that if you want to dismiss an employee, this suspension of work is no more temporary for him or her. Therefore, if you still plan to introduce idle time before staff redundancy, we recommend paying to this employee full base salary. Because in this case, even if idle time regime is introduced, it will not damage rights of the employee to full compensation, and therefore the employee will hardly find a ground to file a claim. If we talk about processing of personal data of employees, including such data as data on health, data on trips, including personal ones, data necessary to formalize home office work, all these data are processed in the current circumstances based on the labor legislation. As, for example, the certain requirements in the decree of mayor of Moscow also belong to labor legislation. As a result, the company does not have to get any consent of employees to data processing in this case. However, there are some exceptions. For example, if for the purpose of arranging remote desktop for your employees, you need to provide their names, email addresses, and maybe also some other data to a service provider or to your group company outside Russia or even inside Russia. You need to get first a written consent of employees with indication of the provider's name and its address. As regards visitors, because many companies now measure temperature or ensure measurement of temperature not only in relation to its employees but also to visitors. So as regards data of visitors, position of the Russian regulator in the sphere of personal data, Roskomnadzor, is now the following: that visitors that do not have labor relations with the company express their consent to collection of data on temperature of their body without further identification data, by way of just doing steps which show that they want to visit the organization. So if you are asked to measure temperature and refuse, you have to leave. Herewith, visitors shall be notified if, for example, such temperature measurement is exercised distantly, and there shall be a relevant notice at the entrance to the office of the company. We consider that in addition to these, companies, in case of necessity, may also refer to the following legal grounds: that measurement of temperature, which is data on health, is basically needed for protection of vital interests of other persons, and receipt of a written consent under these circumstances is not feasible. In these times, challenging times, it is recommended to get from employees contact details of their relatives or other persons for potential emergency purposes. We note here that the legal ground for processing such data would be consents of relevant contact persons. And obviously it is employees who should care about collecting such consents. And finally, so finalizing my presentation before I switch to your questions, I would like to talk a little bit about some prospects, because Corona crisis is generally a ground to look more closely at how your HR structure functions, as to how efficient and sustainable it is in view of such crises as these. And let us look at some important aspects. First of all, objectively, owing to the spread of the virus and imposition of countermeasures, directors and key employees of many companies, after traveling to another company or to home company, another country or home country on a business trip or vacation, will not be able to return and are not be able to return, or have to self-isolate themselves for a long time. So by virtue of the specifics of corporate governance in Russia, the situation for Russian companies may be particularly critical. So for a long period of time, the Russian legislation did not allow that the company has several directors, but the situation changed already in the year 2014. And it's important to know that starting from September of this year, if the company appoints several directors, which is possible for several years, for already several years, and starting from September of this year, it will be even visible in the register whether such directors may act jointly or independently. And the historical impact is that many companies still have only one chief executive officer, general director, and in connection with this fact, business of a company may depend to a large extent on this particular individual, and in the times like that, it may cause a significant adverse effect to the business if this particular individual is unavailable for basically unclear period of time. Accordingly, it is recommended that you take the necessary steps. For example, you could appoint additional individuals to either exercise the functions of the chief executive officer. There could be 2, 3, 4, and so on, such persons, or at least you issue corresponding powers of attorney. I mean that directors issue such powers of attorneys that may have limited scope and other restrictions in order for you to be able to control use of such powers of attorneys. So all this is necessary to ensure business continuity in such times as now. Another important topic is that, as you know, the Russian law is not quite flexible in terms of dismissing employees. And for example, in case of staff redundancy, you have to notify employees first, at least 2 months in advance. And then, if the circumstances change, you have to wait several months before you can hire on this position again. Situations as today require more prompt and flexible reaction. And one of the tools that allow achieving such flexibility better is use of agency personnel. You may say that, okay, leased personnel is banned in Russia since 2016 and significant legal risks apply. But let us look whether legal risks are really so serious in practice. Based on the current court practice, we believe that risks of the companies, at least regarding the recognition of the actual employment relations between the company, the inviting company, and the outsourced personnel, are really low. In general, the court practice develops in favor of inviting parties, despite the prohibition of leased personnel. And the courts refuse recognizing employment relations between outsourced employees and inviting parties. In case there is a service agreement between a receiving party and outsourcing agency. Yes, there is a risk of imposing administrative fines on the company, but it is still possible to mitigate such risks by a number of clear steps. First of all, there should be no documentary evidence of leased personnel, which mainly implies that the contract between the agency and the inviting company shall be structured in a way to avoid any reference to leased personnel. Also, it's important that if you implant external people, that these people at least know the name of their manager at the employing company, at the agency, to avoid the situation that the checks come, ask who is your manager, and they show the manager in the inviting company. They should know their manager in the agency. And for sure, though it may be difficult for certain businesses, it is necessary to ensure clear differentiation between the company's employees and outsourced employees, including different access rights to information systems, references in corporate systems, different structure of mail addresses, and so on. And one more example of flexibility is the topic of indexation. As you know, Article 134 of the Russian Labor Code requests that all employers shall ensure an increase in the level of the actual value of the salary, which includes indexation of the salary in connection with consumer price growth for goods and services. Some companies interpret this rather strictly, that it is an obligation. But if we look at the practice shows that employers may basically define all parameters of such indexations, such as amount of raise. It should not be necessarily equal to growth in consumer prices. It may be lower. Employers may define on regularity of such indexation. They may even decide on the cases when, due to objective reasons, the company does not have enough funds, is not in a good financial position to exercise such indexation. And maybe most importantly, and this is confirmed by the Russian Supreme Court in one of its recent decisions, that if the company stipulates in its remuneration policy that instead of indexation it may conduct other types of remuneration changes that in fact lead to ensuring the level of actual level of salary, such as just increases in base salaries based on performance, payment of bonuses, and so on. So if company exercises other types of such measures, then it is still compliant even if it does not exercise indexation. Therefore, the general recommendation is to make terms for indexation and other types of remuneration, such as bonus payments, to make them flexible, and if we talk about bonus payments, to make always make such payments to look as discretionary ones rather than obligatory ones. Yes, in some cases indexation is required by industrial collective bargaining agreements, but you as employers should not also forget about the tools that the law provides. In this case, you as employer is entitled to refuse acceding to the industrial agreement if you send in a timely manner a reasoned letter of refusal. For example, it is still possible to send such a letter in relation to the industrial agreement on machine building for the years 2020-2022. So basically, this is all what I wanted to tell today from my side. Thank you for your attention. To those, I wish obviously much health to you and your families. And now I will be able to answer your questions that you sent during the presentation. Thank you. The first question is, Andrei, may I ask you to comment on payments that have to be done between March 30th and April 3rd? So basically I commented that if employees stayed outside work, they just get the same salary they would get in the case they would work, which basically means that they keep their base salary. If employees have to work during this period because of exceptions that apply, again they get their normal salary. You can ask now, but what is the motivation? Because some people work and get their normal salary, and some people do not work and get the same amount. Well, I would say that this is a good question, but it is more about HR specifics, and if you want to additionally motivate your people, you can do this. Andre, is suspension unpaid applicable in case an employee refuses for temperature measurement? Yeah, it's a good question. I would say that it is hard to apply suspension in case of a refusal for temperature measurement, because in the decree of Moscow mayor it is explicitly stated that the employer has to suspend those employees who have higher temperature. Therefore, my recommendation would be that you formalize this obligation to measure temperature for employees in a way of issuing the relevant internal resolution. And if employees refuse doing this, you have the right to impose a disciplinary sanction on them. Andrei, what are the conditions to enact idle time if non-working week of present decree is not extended, but company's business went down and company is looking for the ways to save costs? Okay, the question was raised before I started talking about idle time, so I think I already answered your question. If not, please follow up. I will comment further. Andrei, do I understand you right that if a service engineer, as an exception, has to work between March 30th and April 3rd, the company pays him normal wage, not double as on weekend? Yes, my position is that it is exactly so, because in the presidential decree there is the point number 2 where exceptions are listed, and it's explicitly stated that the decree does not apply in these cases. But again, as I said, we've heard a position of a representative of one ministry, and his position was opposite, that even if there is an exception that applies, the company has to pay double amount. I think that this is not correct interpretation, but I encourage you to wait, if not already appeared, to wait until the Russian Ministry on Labor comments further on that, because they should do this. They announced they will do this. Andrei, can we have the summary of the presentation afterwards, or is there an option to listen to it again later? There are some important things to review once more. Yes, as far as I understand from the organizers, this presentation was recorded, so there will be an opportunity to listen to it again. Andrei, what are the risks of not preparing any special documentation for work from home arrangement? We don't need this from the controlling standpoint. Well, the risks, the risk is violation of the labor legislation, because if in the employment contract it is stated that the place of work of the employee is the office of the company, and the employee works from home, so the condition on place of work is not reflected correctly, but this is only one side. Another side is that, for example, if we talk about introducing home office, from my perspective, it is very important to state in the contract that the employee has to work explicitly and namely from home, so not sitting in the restaurant or not being anywhere where the company don't know where, because especially in these times this allows to achieve the main aim of minimizing risks of minimizing risks of coronavirus spread, and on the other hand it generally minimizes the labor safety risks, because if the employee travels during the day, the risk of any accident is obviously higher, and it is the employer that is responsible for labor safety in the case of home office. One of the highly qualified employee is stuck outside Russia due to closing the Russian borders during his business trip. Is it possible to sign a remote work addendum with the employee staying abroad, or it's applicable only for those staying in Russia? I would say that there is a position, though not official, but still a position of the Russian Ministry of Labor that states that they consider that if the employee exclusively works outside Russia, then the Russian employment law does not apply. But I think that this position is too formal, and if you still conclude an employment contract with this person, it will not be a violation of the Russian law, and the risks related to this, so I consider that it does not damage rights of the employer. Even better, it improves the position of the employer. Therefore, I think that yes, it is possible. Andrei, regarding temperature lock, can a company comply with the data protection regulations if an employee can see the data of the others on temperature in this log? This can happen if employee measures temperature on his own and puts down the data. Yes, exactly. This can happen if the employee puts down the data on his or her own, but our recommendation would be definitely that there is an assigned employee in the company who enters data, and the employee, upon measuring temperature, may just tell this person the relevant value, and this person will enter data. Yes, this would be definitely better, though there may be also other solutions in this case, like electronic logs, where employees may enter only their data, but the preferred way is namely to avoid the situation that employees see temperature values of other employees. Can we replace salary indexation by salary review and bonuses? Yes, I said it's possible. And how can those be reflected in the policy? So, based on the position of the Russian Supreme Court, it is just necessary to explicitly mention in the remuneration policy that the company applies different ways to ensure that the real value of an employee's salary is kept, and then list these different ways to ensure that. So this would be sufficient from the standpoint of the Russian Supreme Court. Do we have to pay double for the remote work during next week? Okay, I commented on this already, so hopefully not, but I cannot exclude. So based on the wording of the decree, you do not have to do this. Even if employees work from home on their own initiative without any instruction of the company. So it is not regarded as work on weekend, because these days are not called as weekend days, as выходные дни. They are called as just non-working days without any specification. So I hope that not, but let's still wait. Maybe today evening or tomorrow morning somebody will comment on that, and then we will understand how to deal with it further. So this was the last question, and if you do not have any further questions, thank you again for your participation, and hopefully we will meet again in more pleasant circumstances and in person. Thank you and bye.